second case on this morning's docket. Case number 109086, State of Kansas v. Godfrey.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Cody Godfrey. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, this is just a reminder that this is a felony murder case out of Shawnee County. In this case, Mr. Godfrey entered a guilty plea to felony murder and entered into a sentencing agreement with the state. That sentencing agreement read, this is record 1, page 86, it's in all the briefs. At the time of sentencing, the parties agreed to recommend that the defendant serve his sentence at Larned State Hospital with all sentences to run concurrently without any departures. Your Honor, when we get sentencing cases on appeal, in plea cases, obviously our issues are somewhat limited by the nature of the case. And so what do? We look at that and see, was the proper sentence imposed? And one of the things we look at is, did the prosecutor in a case violate the sentencing agreement or the plea agreement? Because we know that a defendant gives up the whole panoply of fundamental rights in exchange for that agreement. And so the United States Supreme Court and this court have held that we're going to hold prosecutors to that agreement.
And in this case, the sentencing judge pronounced sentence, the term sentence, pronounced whether it was consecutive or concurrent, I don't remember, but went through the whole sentencing procedure, and then indicated that he was going to order that sentence to be served at Larned State Hospital.
That he was going to invoke the 22-34-30 and have Mr. Godfrey go to Larned in lieu of that sentence.
But that's not possible. That's not what the statute said. So his pronouncement of the sentence was an illegal sentence or an incorrect sentence, because 3431C says only after you're discharged from Larned, after you're sent there, does the court proceed to impose a sentence. And so what the judge did, even though he thought he was doing what the parties wanted, that was not a legally correct sentence. Would you agree with that?
I would not agree with that quite exactly, Your Honor, and this is the only point I would make about that. It can't stand like that. But I would argue that when the judge went on in this case and said, according to your plea agreement, I'm going to make all the findings that are required to invoke 22-34-30, and I'm going to do that effectively sort of supersedes any other sentence. He's doing it in lieu of sentencing. And I don't know if it's particularly improper for a judge to say, here's the sentence I would have given, or maybe it's even the sentence that will be imposed in the future. I don't know. I mean, we do that all the time in probation cases, right?
Is this case about breach of a plea agreement, correct? By
Yes.
the state. What did the state do to breach this agreement? The court is not bound by any agreement that and it seems to me the court tried to do what he thought the parties agreed to, but what did the state do to breach this agreement that you're complaining about? I'm not clear, because in reading the record and trying to decipher this, there was a lot of confusion here. But it seemed that both parties tried to go to extremes to see that whatever this language means was met. And so how did the state breach this agreement?
First of all, we have to decide what was the agreement. Analytically, to be able to answer your question, Justice Rosen, how did the state breach this agreement? We have to come to terms with what did the agreement mean. And that's why in my brief I said that's the first thing I think we have to determine. And that's a legal question. That's just a contract question. These are kind of things we decide all the time. So the first question is this agreement that I just read ambiguous? And Your Honor, I would suggest by the way this case transpired, can't we agree it was at least ambiguous?
It seems to me what they were trying to posture was a sentence that somehow would allow your client to serve his sentence at Larned as opposed to DOC or Lansing or somewhere else. Isn't that what they were trying to do?
That they were trying to, but how do you do that? You do that under 223430.
No, you don't. No, you
That's-
don't.
that's
You
right.
can't order, the district judge can't order this defendant to serve whatever term of imprisonment at Larned. You commit to Larned, and they stay there until Larned can provide until they can't get better, however it's worded, and then they're sent back. And at that point, they get given credit for time served there, but then they're sentenced under 34.
Then they may be sentenced.
Under 3431C, then the court imposes a sentence, probation, whatever that's worded. But the point is, what your client wanted, or defense counsel wanted, was not statutorily permissible to impose a term sentence and order that sentence to be served at Larned. Statutorily, there's no authorization for that.
There is authorization for a person to be sent to Larned in lieu of sentencing, though.
But the judge doesn't get to say how long they stay there. Larned says how long.
Larned gets
they
to make that decision.
Yes.
That's right.
Mr. Hodgkinson, I would certainly agree with the statements that have been made so far that this was confusing. At least in the transcript, it's hard to follow who's on first. But at page 46 of the sentencing transcript, counsel for your client says, it's trying to describe what the confusion is or what the client's expectations were, and says that was the confusion previously. This is a difficult statute. There's various areas of things, but basically what Cody is saying is I think he understands that's not going to happen and that he wanted to proceed with the sentencing today after we discuss the various options. Do you think that statement has any legal impact on your client, and what would it be?
Yeah. Again, because I think we have to start with what did the plea agreement say? Let's assume you agree with me for a second. That's a big assumption, I know. But say you assume you agree with me that the plea agreement was ambiguous, and that you assume that you agree with me that when you have an ambiguous plea agreement, you should construe it in favor of the defendant, and that there is evidence in this case, even the district judge, Judge Debenham in this case, read into this plea agreement that what you mean to do is have this person committed pursuant to 223430. So I think that's some evidence on my part that that's a reasonable interpretation. Some district judge thought that was okay. If you agree with that that's what the sentencing agreement meant then. That's what they agreed to. Your question, I think, Your Honor, is then, does this somehow undo that? Or is there a waiver or something like that?
Yeah, a waiver or invited error or something.
And so I would suggest to you, no. That it seems to me what happened here is, if you would agree with me, obviously if I'm wrong about those other things, I'm wrong. If you think this plea agreement's clear and the judge did exactly what this plea agreement said, then we're done. But if you agree that that's not what the plea agreement said, that the plea agreement did contemplate commitment in lieu of sentencing, then trial counsel here thought that she had two options, it appears to me. That she either undo the plea agreement, or go forward with sentencing. Keep the plea and go forward with sentencing. Your Honor, I would suggest to you there's a third option. Enforce the plea agreement. And she didn't do that.
A modified plea agreement, because if you enforce the plea agreement as was stated, that would have been an illegal sentence, and you can't force the judge to impose an illegal sentence. The judge would have had to use the statutory form, and you have a 3429 evaluation and then 34 30 says, you know, how you send them to Larned. 31 then talks about how long they stay and what happens when they come back. But that isn't what they were asking to happen. So what you're saying, the third option would have been to impose a modified sentence or modified plea agreement.
It's not what I'm trying to say, Your Honor, that you should construe the plea agreement in this case as a legal plea agreement, but that the intent of my client, as evidenced by what his attorney said, was that they were going to invoke the provisions of 223430. And that's a reasonable interpretation of that plea agreement, this ambiguous plea agreement, as evidenced by the fact that that's exactly what Judge Debenham thought they were doing.
But can a party commit a breach of a plea agreement that, as they understand it? I'm just wondering if we're kind of conflating principles here. Certainly if we construe an ambiguous plea agreement against the state, but I'm wondering if that's different from saying the state can breach a plea agreement if they do what they understand the plea agreement to say and what they believe the statutes provide as what would be legal under the plea agreement.
At the end of the day, it seems to me like the plea agreement has to have a single meaning. It's a question of law. And this court or the district court has to say, this is what this plea agreement meant. Now, and so let me finish the answer. So either party might have inadvertently argued against that. I understand that the prosecutor in this case thinks that there's a different plea agreement. But at the end of the day, if this court says, as a legal matter, as a question of law, this plea agreement, the agreement looked at in the favor deference to the defendant was to invoke the provisions of 223430, then it doesn't matter what the prosecutor's intent was. The prosecutor did argue against that, as a matter of fact. That's why, Your Honor, we're not...
Explain to me your ambiguity, I think, is maybe where I'm having trouble. The actual language is recommend that the defendant serve his sentence at Larned State Hospital. How could he actually serve a sentence, an imposed sentence, a term of imprisonment at Larned State Hospital without being sent there from the DOC, as the prosecutor indicated that he understood? How can he serve his sentence at Larned under the 3429, 3430, and 3431? How can that happen?
Your Honor, I would agree with you that's an ambiguous point in the agreement.
Well, no. How can he serve his sentence? It might happen if Larned says he never gets better, but there's no way for anyone to order that happens because it's up to Larned. So I don't understand how you have two ways to serve the sentence at Larned.
I'm not disagreeing with you on your legal analysis, Your Honor, but the way you serve a sentence at Larned is you invoke the provisions of 223430. And you're right, I'm not disagreeing with you that that's not serving a sentence, it's in lieu of a sentence.
Yeah.
But that's what even Judge Debenham thought was going on here. That's what defense counsel thought was going here. And I would say that that's a reasonable interpretation. You and I would correctly parse out and go, that's not the language you should use if that's what you want to do. But this is the language we're stuck with. And the question is, could this reasonably be interpreted to mean that we intend to invoke the provisions of 223430?
And what's the remedy that you could get here?
Yeah, in fact, that's one of the points as I prepared. The remedy I stated in the brief, which was, my sort of boilerplate violation if the prosecutor violates a plea agreement, which is go back to a different judge and enforce the plea agreement. I think in this case, though, maybe it's different because we actually had the district court do what I'm arguing was the plea agreement in this case, which was invoke the provisions of 223430. So really the remedy would be to put the client back where they would have been before the prosecutor's breach in this case.
And are you gonna have to recommence the whole thing? I mean, a judge can't just send someone to Larned in lieu of sentencing without some evaluation indicating there's a reason to do so.
Yeah, the judge had an
Right.
evaluation at sentencing in this
Well,
case.
but that was then. Do you have to recommence the whole process? Because, I mean, part of the reason here was to get this fellow back on medications, and so, if he happens to be back on medications, it may not be such that he meets the criteria to be sent.
yeah,
So
I haven't-
that's what my
Sure.
problem is I'm not certain we can go back and do now what might have been done then.
Yeah. I think that, I haven't thought that through that far, Your Honor, but it certainly seems reasonable perhaps that if you remanded, if you agreed with me, you said, look, this is what the agreement was, and we need to go back, but we have to recognize maybe you need to have an evaluation now to see, does he still fit the criteria that he met when Judge Debenham made that finding before? Or, has he been treated and cured? And this no longer would apply to him at all. Although, even in that situation, Your Honor, I would still say he should get the benefit of the findings that Judge Debenham made, the 22, 34, 30 findings, because that substantively changes his rights. Because when he comes back, he doesn't necessarily get sentenced. It's an option, but it's not necessary. And so I would say even in that situation, if that's what the judge found, then the judge should say, well, I'm going to put myself in that position like he had come back from Larned at that point.
I'm not sure if whether to label this a preservation issue or a interpretation of the plea agreement issue, which column to put it in. But it seems to me that when I look at the transcript, and the note I made to myself was after the colloquy that we have, it seems obvious the defense counsel, the state, and the judge all ended up in the same place when the discussion concluded. And I don't know how else to explain defense counsel saying, quote, there was a disagreement among the parties, but we are willing to go ahead with the plea, close quote. I mean, like, how you label that, it seems like everybody knew what they were doing by the time they were done. And there certainly wasn't an objection that the state was breaching the understanding that counsel had. So how do we go forward?
It's two answers. First of all, I think the construction that I'm asking this court to do, and I think you're required to do, is interpreting the plea agreement at the time that Mr. Godfrey waived all of his panoply of fundamental rights. And so that's the time that we have to be considering here. So even if the parties later said whatever they said, this agreement still said a certain thing and meant a certain thing at the time, as a matter of law, at the time that that Mr. Godfrey waived all his rights. So the second question then, and this is I think related to Justice Breyer's question, is this sort of a waiver or an acquiescence or invited it or these different things that it could be? And I would suggest that for two reasons, no. One, I don't think this court has ever really said sort of acquiescence as a defense to prosecutorial breach of a plea agreement. The second thing is, all the people that you listed there, Your Honor, that we're talking about this, who was missing? Mr. Godfrey. If this was some sort of a modification of the plea agreement, if they came in, this is what, and Justice Johnson, if it was a modification of the plea agreement, it seems to me that maybe, given the law of plea agreements, Mr. Godfrey should have been a part of that discussion in that colloquy. And it seems to me he's entirely missing from this discussion.
Counsel, let me just do what Justice Biles sort of hinted at and take all of this, for at least for the moment, out of the universe of waiver and acquiescence and put it squarely in the preservation universe. Your allegation is that the state breached its agreement, correct? And that
Yes.
that raises a due process problem. You would agree, however, that there was no objection raised at the lower court to this alleged violation of the agreement, right?
Yeah, well,
There's no objection in the record.
there's no. They
The
they
defense
never
can-
say there's an agreement, but they say they don't want to undo the plea agreement, and so they want to go
The
forward.
defense counsel never stands up and says, I object. The state is not following what it said it would do. The state is violating our plea agreement.
The defense attorney said, we disagree about what the plea agreement says.
And then the defense attorney said, "But we're okay with it." I mean, those aren't exact words.
The
but-
defense attorney says, we don't want to undo the plea, we want to go forward
Well,
with sentencing.
are you alleging that an objection was lodged? That's just yes or no. Was an objection lodged from your perspective?
No.
Okay, so you're asking us to answer a constitutional question for the first time on appeal, which we don't usually do, right?
I think it is done quite often in cases of prosecutorial breach of.
And there are exceptions to that. I mean, that's what I'm getting
It's
at.
purely a question of law, so there's no
Okay,
reason this
so
court can't.
we
go
have three
forward.
exceptions for reaching a constitutional question for the first time on appeal. And you're pinning your case, at least in the preservation universe, on that first exception. That
I
it's
would pin it
purely a
on-
question of law arising on admitted facts.
And I would also pin it on failure to reach this issue would result in a denial of fundamental rights, the due process right.
Did
The
you
most
argue?
important right.
Did you argue either of those points in your brief?
Would have to look, whether I said it was an issue of law. My colleague noted that it was an issue of law, purely an issue of law. So I don't think that's really questioned in this case.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Good morning. May it please the court. Jody Litvin on behalf of the state. I think we can all agree that this is a really confusing sentencing, but I guess the state's main points here that I wanted to hit on this morning were just what you were talking about there, Justice, about the preservation issue. I think there was a lot of confusion post-plea. I think there was an initial sentencing where the defense counsel wanted to withdraw the plea and made some comments about there being a miscommunication about what that sentencing agreement language meant. And I think that was resolved by the end of this sentencing. And there was no objection. There was no further misunderstanding at the end of this sentencing.
What's your understanding of what the language of the sentencing agreement meant? At the time of sentencing, the parties agreed to recommend that the defendant serve his sentence at Larned State Hospital. What does that mean?
Well, certainly it doesn't mean the invocation of the 223430 commitment in lieu of sentencing statute.
So then, if that's not it, what does it mean?
What I believe it means, which I don't know if we've hit on this yet, is that the district court can make certain recommendations. Now, I understand they have no authority to tell the DOC, you need to send him to this prison, this defendant to this prison for this reason. They have no authority to do that, but they can certainly make recommendations. And often in plea agreements and in plea negotiations, it's my understanding that the defendant wants the district court to make those recommendations, that they mean, they're important for the defendant. So my understanding...
So that's your understanding, is that it's a joint recommendation to the court to recommend to the DOC that the defendant serve his sentence at Larned.
Yes.
That's what it means.
And for what that's worth, that's what the recommendation was. Knowing without that there's no authority for this, it was a recommendation for a recommendation. And that was my understanding of what happened. Which is why our point, why we argue, and it's the state's position that the prosecutor didn't violate the plea agreement here. She was simply stopping the district court from doing something that, as Justice Johnson pointed out, he couldn't do, and then they re-argued their positions on what the agreement actually was. And I think once we look at that re-argument, both parties agree that this was just a recommendation for the district court to recommend that he serve his sentence at Larned. And I don't know that there's any authority for the DOC to even do that, but I didn't look into it that far, but I know that the DOC has control of where they place people to serve out their sentence.
Where you started was telling us it was confusing and that there appeared to be a misunderstanding of the plea agreement.
Yes.
And that by the end of it, that seemed to have been resolved. But isn't the only statement we have that it was resolved is Ms. Asher's statement on behalf of her client? Was there any inquiry of Mr. Godfrey or any determination that he understood now what was going on and agreed to it?
Without looking right at this moment, I don't know that they ever went back to Mr. Godfrey. I know he got a moment to speak, and this could have been before all of this discussion and confusion was explained by Ms. Asher. I don't know if they ever went back to Mr. Godfrey and asked him. But I mean, I think we should take the defense counsel's statements and I think we should trust them. If she had further discussions with her client post-plea after that first sentencing was scheduled, and they said that they discussed the various options, and 223430, commitment in lieu of sentencing, was not on the table, and from the state's position, it was never on the table. It's not something that we agreed to. That's not what that sentencing recommendation meant. She spoke with her client about that, and he agreed to go on with the plea. I think this court can trust that. I think the counsel...
What was the time frame? What after the judge announced what the defendant thought was the plea, and the prosecutor intervened and said, no, it's different. Was there another day? What was the continuation of sentencing another day, or was it that same day, or do you know? Because there was some indication in there that there may have been a discussion about a motion to withdraw a plea, and I didn't know if that was like go out in the hallway and talk about it, or if there was an opportunity to have given this some serious discussion between counsel and defendant.
From what I remember, although I've got all the dates of the proceedings over on counsel table, they went to the plea agreement, and then they had a scheduled sentencing. I don't know how far apart those were, but that initial sentencing, right from the get-go, out in the hall or maybe before the proceedings, the miscommunication came about, and they understood then. And then I think that she had the district court set a week for her to file that motion to withdraw a plea. So I'm assuming that in that time.
Okay, so in other words, my question was there a resetting of the sentencing for a later date to
Yes.
give an opportunity to file a motion to withdraw?
Yes, and I think it was about a week. Then the state had an opportunity to reply, and then there was a second sentencing set. And then at this second sentencing, I think Ms. Asher explains, I didn't file a motion to withdraw a plea, and I can get to that. And the district court says, well, let me make some findings first, and then we'll get to that. And then her explanation of kind of all of the miscommunication about what that language meant was had. So I don't think this court should go down the road that this was ambiguous. I think that, number one, it's not preserved because there was no objection and the explanation from defense counsel here, I think it resolves the entire issue. And I don't think that the prosecutor here violated the plea agreement because she was simply going on what the understanding of the parties was and refocusing the district court on what the recommendation was. And if there's no further questions, I don't think I have any more presentation.
Any more questions? Thank you, counsel.
Thank you.
Justice Stiegel, I just wanted to respond. I mean, I did argue that it was a due process violation and that it was an issue of law over which this court exercises unlimited review.
Thank you.
I did not, I have to admit. I didn't say, and that's a reason in lieu of lack of an objection. The prosecutor's interpretation of this plea agreement was
I was going
reasonable.
to ask you about that.
Yeah.
It's as reasonable as your interpretation, isn't it?
It is. I'm not really disagreeing with that. But the law under Wills is if there are competing reasonable interpretations, that equals an ambiguous agreement. And I guess that's the only point I would sort of rebut is it wasn't a situation where they resolved and said, this was always our understanding. Even to the end, the defense attorney continues saying, this is not what we thought it meant, but we want to keep going forward. We don't want to undo the plea agreement. As opposed to saying, this is not what we thought, and Your Honor, we want to enforce what we thought in this case.
Is your understanding or your client's understanding of the plea agreement reasonable when it was legally impossible?
I think it is reasonable in that, I mean, I could, if I parsed this language as hard as you are, Justice Johnson, then the state's suggestion is unreasonable, because it is also the case, I think, that the parties time of sentence, the parties agree to recommend that the defendant serve his sentence at Larned State Hospital. That's not possible legally either. And so,
Well, it is
if we're
possible.
parsing it that hard,
Counsel, it is possible if the Department of Corrections assigns Mr. Godfrey to Larned.
but that's something over which the parties and the court have no control.
Well, isn't that why the word recommend matters a lot?
That the parties agree to recommend that the defendant serve his sentence, i.e. the parties agree to recommend to the district court that the district court order that he serve that sentence in Larned. That's just as unreasonable. But I would say, if I don't parse it quite that specifically, then it becomes reasonable. If I understand that it could mean that. That's one thing it could mean. But it also could mean, as Judge Debenham thought and as defense counsel thought, that it means we're going to use this provision of 223430. And you're right, that would mean you're not actually sentenced. The district court in this case could have resolved this question and said, you're right, I can't do both. I'll vacate all the sentencing that I did, and I'll just go under 223430.
The rest of that sentence, after it says recommend that the defendant serve a sentence at Larned State Hospital, comma, with all sentences to run concurrently without any departures, which indicates that seems to be an agreement with regard to the actual sentencing. And as we've indicated, that doesn't happen before you go to Larned. That's a post-Larned situation by statute.
If you go to under 223430.
To resolve the alleged ambiguities in the agreement within the four corners of the agreement, can't we go to other provisions of the plea agreement wherein it is clear that the parties state that the sentences have there's a certain number of months, and that those sentences are served in the custody of the Department of Corrections?
That's a potential sentence.
But read together with the disputed clause where...
Are you talking about paragraph 5 where it talks about sentencing options?
Right.
Yeah, and as in every plea agreement, it has to say, here's the maximum possible penalty.
And it says those sentences are in the custody of the Department of Corrections.
That's possible, yes.
And read together with the disputed clause that, as Justice Johnson just said, says the sentences shall, the recommendation is that the sentences run concurrently without any departures. Now, what sentences is it talking about? It's talking about those potential sentences in paragraph 5, right?
I think paragraph 5 would look exactly the same, even if I had my unambiguous, what I would say, that the parties recommend that the district court commit Mr. Godfrey to Larned in lieu of sentencing. Paragraph 5 would still look exactly the same because the district court has to inform him of the possible penalties in case that the judge doesn't follow that recommendation.
I guess my question is, in that last clause, with all sentences to run concurrently without any departures, what sentences does that refer to?
If I'm allowed to, again, interpret this ambiguous, then that means if I am ever sentenced, as I might be, even under 223430 someday, that would be the sentencing provision that would apply.
Okay.
I think where we're coming down, and maybe it's like, as you say, parsing or putting too fine a point on it, but under the 3430 commitment, you indicated that that's in lieu of sentencing. So technically, a defendant is not serving a sentence when you go to Larned under that procedure.
I think that's right.
Yeah, and so we have to read that serving the sentence didn't mean serving the sentence.
Although I don't know, again, that it's impossible or illegal for a district court to set a sentence, just like we do in probation cases all the time, right?
But
district court says, here's your sentence. You may never serve it.
I
but
understand the
I'm
argument that you could
imposing
say,
it.
when you get out of Larned, here's your sentence. But you would agree that under the language of the statute, when you're sent under 3430, you're not serving a sentence. You're at Larned in lieu of a sentence.
In lieu of a sentence. I think that's right, yeah.
Yeah.
I can't.
Okay.
Any more questions? Thank you,
Thank you.
counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time.